My name is Pierce O'Connell, and I'm a Trade Adjustment Assistance Rapid Response State Coordinator with the Michigan Department of Labor and Economic Opportunity, otherwise known as LEO, Workforce Development. In this video, you will learn the requirements of the Worker Adjustment and Retraining Notification Act, also known as the WARN Act. Please find various resource videos and links in the video description below. The WARN Act requires employers to provide at least 60 days advance written notice of a mass layoff or plant closure. An employer is required to submit written notice to the chief local government official, the Michigan Department of Labor and Economic Opportunity, Workforce Development, and impacted employees or their labor representative where applicable. Employers are required to submit a WARN under the following circumstances. In the instance of business closure, if it results in employment loss of 50 or more employees during any 30-day period. In the instance of mass layoff, a covered employer must submit notice if the employment loss is 500 or more employees, or if the employment loss is between 50 and 499 employees, and it will make up at least 33% of the employer's active workforce. For employees laid off for a period of less than 6 months, a WARN is not required. Please visit our website in the description below for additional information. There are 3 exceptions to the 60-day advance WARN requirement which can be applied. The following 3 exceptions include 1. Faltering company. This exception covers situations where a company has sought new capital or business to stay open and where giving notice would ruin the opportunity to get the new capital or business. This exception applies only to plant closings. 2. Unforeseeable business circumstances. This exception applies to both closings and layoffs that are caused by business circumstances that were not reasonably foreseeable at the time notice would otherwise have been required. These are circumstances that are typically caused by some sudden, dramatic, and unexpected action or condition outside the employer's control. If you are submitting a WARN due to the COVID-19 crisis, unforeseeable business circumstances would be applicable. 3. Natural disaster. This applies where a closing or layoff is the direct result of a natural disaster, such as a flood, earthquake, drought, or storm. These exceptions do not eliminate the employer's obligation to notify relevant parties. However, employers should give as much written notice as possible and indicate which of the exceptions they believe the delayed notice would fall under and why. There are various services that may be available to impacted employers and employees. Check out the description below for additional information. If you have any additional questions regarding the WARN Act in Michigan, you can reach out to the Michigan Department of Labor and Economic Opportunity by phone or email by following the links in the description.